welcome back uh, in today's lecture. And now, in this part of the lecture, students, we are going to learn and we are going to discuss our remaining topics. And I'm going to begin this part of lecture with the topic that is the terrorism, thereafter torture, and corruption. So here is the slide of further topics which we are going to discuss. So here's the introduction of the terrorism, and terrorism as an international crime. Students, international terrorism has therefore far proved particularly difficult to regulate due to the lack of the common accepted legal definition of the that phenomena. As we know, because this is not a new phenomena, terrorism. The definition of terrorism too difficult to define because there's a it is the aggregate and extreme level of the crime. There's the element of the there's the element of the fear and shock, and there's the extreme barbaric element in that type of the crimes. The international community has been struggling for decades to reach a consensus on whether a crime of the terrorism exists under international law, and if so, what elements would constitute that crime. The main contentions or main contentious question is whether freedom fighters engaged in national liberation movements could be classified as a terrorist, uh, and as a consequence, no legally binding instrument laying down a comprehensive definition has yet been concluded. Because sometimes those freedom fighters become the terrorists, and those terrorists sometimes become the freedom fighters. So, uh, in the societies, in the nations, the some fightings regard as the regard or known as the terrorism and terrorists, and same in other society, in other part of the world, those terrorists called heroes and freedom fighters. So arguably, a consensus on a generally acceptable definition could be agreed upon. Some scholars even argue that a widespread consensus on a generally acceptable definition has evolved in the international community, which constitute a customary rule on the constitute rule on the physical and mental elements of the crime of the international terrorism in time of the peace. However, and disagreements remain so as to the existence and the extent of exception to such definition, namely whether to exempt from the definition acts that, although falling within the definition of the terrorism, are legitimized in law by their being performed by the freedom fighters engaged in the liberation wars. So, what is the legal instrument on the terrorism? International terrorism conventions. Disagreements over the constitutive elements of the terrorism have limited in the international regulation to 16th Universal Instrument against the international terrorism, comprising 13 thematic conventions and 3 amendments. These instruments have been elaborated within the framework of the United Nations system relating to the specific terrorist activities. Therefore, they criminalize specific acts as the terrorist offenses rather than attempting to criminalize terrorism in its entirety. They oblige state parties to incorporate the regime into their domestic laws by decriminalizing the specific offense and providing penalties. States are further required to either extradite the offender or to consider the case for the prosecution, and to provide each other with the mutual legal assistance in extradition and the criminal proceedings. The question arises here: the jurisdiction of the state parties to these international terrorism differs according to each individual convention. Most of these conventions base jurisdiction on the territory upon which the offense was committed or on the nationality of the offender. Others allow for jurisdiction to be established according to the nationality of the victim. For example, in 1997 Convention for the Suppression of the Terrorist Bombings obliges the state parties to exercise jurisdiction over an offence when it is committed on its territory, on its ships or aircrafts, or by its nationals. So there are three methods, there are three ways the act can be considered under the ambit of the terrorism when the uh, offense, when it is committed on its territory, means the geographical location, on ships sailing carries the passengers or shipments or any consignment in sailing, or on aircrafts or by its nationals. A state party, however, is also permitted to exercise jurisdiction over an offence when it is committed against a national or against a state or government facility of that state abroad by stateless persons who reside in the territory of that state, or if the offence is committed in order to coerce the state to do or not abstains from doing that act. Regulation of international terrorism by these international terrorism conventions extends only to offences defined by these conventions, such as hostage taking, financing terrorism, bombings aeroplane, hijacking, other offences against air travel, and the like. Regulation is further limited to acts of the international terrorism, acts of the terrorism not of international character, that is, acts committed within a single state where the offender is national of that state, the victims are nationals of that state, and the offender is found in the territory of that state, are not considered acts of the international terrorism for the purpose of these conventions. So, next topic for the discussion is the United Nations Security Council resolutions. What those resolution address the international crime of the terrorism. The United Nations Security Council has been dealing with terrorism issues since early 1990s. In response to specific acts of the terrorism, the Security Council determined that the suppression of the international terrorism was essential, significant for the maintenance of the international peace and security. The Security Council imposed sanctions against Libya and Sudan for not complying with its request for the surrender to justice of the persons accused of the specific terrorist acts. Libya was requested to surrender two individuals who were accused of being responsible for the explosion of the Pan American Flight 103 over the Scottish town of Lockerbie in 1988. Sudan was requested to surrender three persons accused of attempting to assassinate the president of Egypt in 1995 uh, in the Addis Ababa in Ethiopia. And similarly, in the wake of the terrorist bomb explosion outside the United States Embassy in Kenya and Tanzania in 1998, the Security Council adopted Resolution number 1267, which passed in 1999, in which it imposed sanction under the Chapter 7 against the Taliban for their failure to comply with its request to stop providing sanctuary and training for international terrorists and their organizations, and that all Afghan fractions cooperate with efforts to bring indicted terrorists into justice. The section including the freezing of the funds and other financial resources, including funds derived or generated from the property owned or controlled directly or indirectly by the Taliban. Further, moreover, the Security Council also requested the Taliban to turn over the Osama bin Laden to the authorities to country where they had been indicted. For the purpose of overseeing the implementation of the sanction of Security Council, established a committee consists of the all members of the Security Council. The sanctions regime has been modified and strengthened by the subsequent resolutions so that the sanctions measures now apply to the designated individual groups, undertaking, and entities associated with the Al Qaeda, Osama bin Laden, and or the Taliban. States are required to implement three sanctions measures, namely to freeze the funds and other financial assets or economic resources of these individuals. Means by this resolution, Security Council also bound the states and their individuals do not support the that organization which defined by the United Nations as the terrorist organization. So groups undertaking the entities and to prevent the entry into or transit through their territories of these individuals, and last third category to prevent the direct or indirect supply, sale or transfer to the designated individuals, groups undertaking or entities of the arms and related material of all types of including weapons and ammunition, military vehicles and others. The Sanctions Committee, also known as the Al-Qaeda and Taliban Sanctions Committee, maintains a regulatory updated list of the designated individuals, groups, undertakings, and entities that serves as the foundation for the enforcing the sanctions. In the latest resolution adopted within the Al-Qaeda and Taliban sections regime, United Nations Security Council Resolution 1822 in 2008, the Security Council reaffirmed that terrorism in all its forms, skins, and kinds, types, and manifestations and constitute one of the most serious threats to the peace and security, and that any acts of the terrorism are criminal and unjustifiable regardless of their motivations whenever and whoever committed, and its unequivocal condemnation of the Al-Qaeda and those other activities, organizations and other individuals, groups, undertakings and entities associated with those terrorist organizations for ongoing multiple criminal terrorist acts aimed or causing the death of the innocent civilians and other victims, destruction of the property, and greatly undermining the stability of the state and world at large. Those The phenomena of the terrorism and the map of the world, or in the become the highlights of the each and every media and newspapers after the 9/11, when the Trade Center was collapsed by the test attacks by the planes. So attacks against the United States, the Security Council adopted the resolution 1373 in 2001 under the Chapter of 7 of the United Charter, which obliged the state to take a number of the measures to prevent terrorist activities and so criminals various forms of the terrorist actions. In particular, states are required to criminalize the financing of the terrorism, freeze any funds related to the persons involved in acts of the terrorism, deny all the forms of the financial support for terrorist groups, suppress the provision of the safe havens sentences or support for the terrorist, criminalize active and passive assistance for the terrorism in domestic law, and bring violators to justice. In addition, states are obliged to take measures that assist and promote cooperation among the countries, including adherence to the international counterterrorism instruments. So, in this regard, in 97, the another resolution 1373, and the same resolution which established a counter-terrorist committee composed of the all United Nations Security Council members to supervise its implementations. States are required to report regularly to the committee on the measures they have taken to implement the resolution by determining that any act of the international terrorism constitute a threat to international peace and security. The Security Council adopted a general definition of the threat to peace and security which is no longer necessarily linked to any specific situation. It should be pointed out that the obligation imposed by the Security Council in Resolution 1373 are not sanctions but measures that resemble and model legislation. In a further resolution 1566 in 2004, Security Council reaffirmed that terrorism in all its forms and manifestation constitute one of the most serious threats to the peace and security. Acting under the Chapter 7 of the Security Council, called upon a state to take actions against the individuals, groups, and entities engaged in terrorist activities other than those uh, sections under Security Council Resolution 1267 and the 99 Resolution 1566 2004 established a working group made up for Security Council members to recommend practical measures against such individuals and groups, including more effective procedure considered to be appropriate for bringing them to justice through prosecution or extradition, freezing their assets, and other measures to operative part of the resolution. Uh, if you will go through the operative part of the resolution, you will find other actions which states has to be taken coercive measures against the terrorist activities, which all forms of the criminal activities within their states. So next topic, students, the efforts to drop a comprehensive convention on the international terrorism. In 1937, the General Convention for the Prevention and Punishment for the Terrorism was drawn up within the League of Nations, but it failed to secure sufficient ratification to enter into force. The convention defined acts of terrorism as criminal acts directed against a state and intended or calculated to create a state of terror in the minds of the particular persons or group of the persons or the general public, and listed acts to be criminalized by the state parties including those causing death, serious injury or loss of liberty to heads of the state and public officials, damage to public property of another state, and risk to the lives of the member of the public. As mentioned above, as discussed earlier, various thematic conventions have been adopted since then, each of them prohibiting specific terrorist acts. In 1999, International Convention for the Suppression of the Financing of the Terrorism. So after this, there are two terror financing, especially terror financing added to some specifically enumerated acts of any other act intended to cause death or serious bodily injury to the civilian or any other persons not taking an active part in the hostilities in a situation of the armed conflict, when the purpose of the such act by its nature or context is to intimidate a population or compel a government or an international organization to do or not or to abstain from doing any act. So in order to those efforts to eliminate or remove the international terrorism have also produced results on the regional level by adoption of the numerous regional convention on the international terrorism. These regional conventions take a different approach to regulating terrorism than that of the international terrorism conventions. Rather than criminalizing specific acts, the regional conventions are more general in their approach, and majority of them regulate terrorism through a comprehensive definition. So the definition of such example of the comprehensive legal definition of terrorism, which is the terrorism means an act of the violence or threat thereof, notwithstanding its motives or intentions, perpetrated to carry out an individual's or collective criminal plan with the aim of uh, re- uh, terrorizing people or threatening to harm them or impaling their lives, honor, freedom, security, or rights, or exposing the environment or any facility or public or private property to hazards, or occupying or seizing them, or endangering a national resource or international facilities, or threatening the stability, territorial integrity, political unity, or sovereignty of the independent states. So this is the one of the definition of the comprehensive legal definition of the terrorism. United Nations member states are currently negotiating a draft comprehensive convention on the international terrorism. The General Assembly has entrusted its ad hoc committee with the task of elaborating the draft comprehensive convention on the international terrorism, including the consideration of the question of convening the high-level conference under the United Nations. This convention would complement the existing framework of the international anti-terrorism instrument, and would build on key guiding principles already present in recent anti-terrorism conventions. So those are the principles. Number one, the importance of the criminalization of the terrorist offenses, making them punishable by law, and calling for the prosecution and extradition of the perpetrators. The need to eliminate legislation which establish exceptions so such criminalization on political, philosophical, ideological, racial, ethnic, religion, and similar grounds. A strong call for the member states to prevent terrorist acts, and emphasis on the need for the member states to cooperate, exchange information, and provide each other with the greatest measures of the assistance in connection with the prevention, investigation, and prosecution of the terrorist acts. So, next topic is regarding the what the International Criminal Code Statute cover regarding the terrorism. Due to the lack of the internationally acceptable definition of the terrorism, the international community was unable to include terrorism within the jurisdiction of the ICC. Other factors which precluded ICC over the discrete crime of the terrorism were concerns that some acts of the terrorism would be insufficiently serious to warrant prosecution by the ICC, and the fear that the inclusion of the terrorism in the statute would politicize the court. However, Resolution E passed during the Rome Conference in 1988 recognized that terrorist acts by whomever and whoever perpetrated, and whatever their forms, methods, or motives, are serious crimes of the concern to the international community. The resolution also expresses regret that no generally acceptable definition of the crime of the terrorism could have been agreed upon for the inclusion of within the jurisdiction of the ICC. The resolution therefore recommended that a review conference, which will be convened in 2010 in Kampala, Uganda, pursuant to Article 123 and ICC Statute, consider the crime of the terrorism with a view to arriving at the acceptable definition and its inclusion in the list of the crime within the jurisdiction of the ICC statute. So, students, it was the brief and thorough introduction and discussion on the terrorism.